16 years ago, Norman Wyatt was a widower with 2 children, a rusted white van, and 3 government inspection contracts he had nearly talked himself out of bidding on. 16 years later, he sat at a mahogany defense table in a Toronto arbitration chamber and watched the lawyers across the aisle prepare to dismantle everything he had spent those years building. The number on the table was $420 million. The assessed value of Wyatt Structural Group, and the men and women who wanted it were patient, polished, and very nearly certain they had won. What they did not know was that a door at the back of the chamber was about to open. But that is where the story ends. It begins on a Thursday night in February on a GO Transit platform outside Hamilton, with sleet coming sideways off Lake Ontario and Norman Wyatt pulling his collar up against it. He was 43 then, though he looked older on hard weeks, and that particular week had been hard. He had just spent 11 days on a remote inspection job outside Sudbury, crawling through the undercarriage of a highway overpass with a flashlight and a measuring tape, and he wanted nothing more complicated than to get home to his son Rowan, who was 13 and had been staying with a neighbor, and who, Norman knew, would still be up when he heard the front door open. He had taken the GO train from Union Station rather than driving, because he had been on the road for nearly 2 weeks and his hands were tired of gripping things. He was standing near the south exit of the platform when he saw her. She was sitting on a concrete ledge with her back pressed against the wall of a closed maintenance shed, knees drawn to her chest, wearing a school hoodie that was far too thin for February. She had a backpack wedged under her knees like she was protecting it even in her sleep. But she wasn't sleeping. She was watching the people pass, with the kind of stillness that a child learns when she has already discovered that drawing attention to herself rarely ends well. She looked to be about 16. She had a bruise along her left jaw, faded but there. Norman slowed. He was not a man who moved on impulse. His whole profession was built on methodical caution, on checking twice, on never signing off before you understood what you were signing off on. And he knew that a grown man approaching a teenage girl alone, on a platform, in the middle of the night, could frighten her in ways that would make everything worse. He stopped about 10 paces away and crouched down so he wasn't standing over her. He asked if she was waiting for someone. She said no. He asked if she was all right. She considered that for a long time before saying that she didn't know. Her name was Blythe Henshaw. She told him that much, and little else, in the careful way of someone who had learned that information given freely could be used against you. She was in a foster placement in Burlington. Something had happened there. She didn't say what, and Norman didn't press. She had taken the train to Hamilton because it was a direction, and directions were better than staying where she was. Norman went to the call box at the end of the platform and phoned the Children's Aid Society. He gave them the location, he gave them Blythe's name, and he asked them to send a worker because he wanted this done the right way. In the light, with someone official, with nothing hidden. Then he went to the Tim Hortons inside the station and bought 2 large hot chocolates and carried them back. He set one down on the ledge beside her without making her take it. She looked at it the way you look at something that might be a trick. After a long moment, she picked it up and held it with both hands. They sat in silence while the sleet ticked against the glass overhead. Then Blythe asked him, in a voice that carried more weight than any 16-year-old voice should have to carry, "Are you going to forget about me after tonight?" Norman went still. He had heard some version of that question before, in his son's voice on the nights he came home late from a job site and Rowan pretended to be asleep, and in his own chest, years before that, as a boy waiting for a father who never held a consistent schedule and never quite learned to warn anyone when he wouldn't be back. Norman understood that Blythe was not asking about tonight specifically. She was asking whether she was the kind of person anyone chose to keep track of. He told her honestly that he didn't know what the next steps would look like, but that he wouldn't leave before someone from the CAS arrived, and that he would give his name and number to whoever came, and that he meant to follow up. She nodded once and didn't say anything else. She finished her hot chocolate and held the empty cup and waited. The CAS worker arrived 40 minutes later. Norman stayed until he had spoken with her, given his contact information, and ensured that Blythe had been seen and that a safe placement was being arranged for the night. Then he went home to Rowan. But he did follow up, that part matters. He called the next morning and the morning after that, and he navigated the paperwork and the home visits and the interviews with the particular patience of a man who has learned that complicated processes don't respond to frustration. They respond to showing up consistently until the file moves forward. 8 months later, Norman Wyatt became Blythe Henshaw's legal guardian. 14 months after that, he adopted her. On the night the adoption was finalized, he pressed something into her hand, a spare key to the front door of his house in Dundas, on a keychain with a small brass maple leaf that he had bought from an airport gift shop years ago and never gotten around to using for anything. He told her what he meant by it, in as few words as he could manage. He said, "In this house, the door is always unlocked for you." Blythe looked at the key for a long moment. Then she closed her fingers around it. The years that followed moved the way years do when they are full, too fast in retrospect, measureless in the living. Norman kept his inspection contracts and added more. And because he understood the infrastructure files that the big engineering firms dismissed as tedious, he began to see the patterns they missed. He knew how bridges aged. He knew what a stress fracture looked like in its early stages and what it cost to address it then versus what it cost to address it after. He knew because he had spent 15 years in the field with a flashlight and a clipboard, not in a boardroom approving slide decks. He founded Wyatt Structural Group from the garage of his Dundas house, with Rowan doing data entry on a laptop at the kitchen table, and Blythe sitting cross-legged on the floor reading through the fine print of his first major contract. She was 17 then, and she had the habit, absorbed from Norman during those early months, of reading every document to its end before forming an opinion about it. She had found a clause in that first contract that would have permitted the client to extend the payment terms unilaterally by 60 days. Norman hadn't caught it. He amended the contract before signing. He told her afterward, in the way he said important things, quietly, without making a production of it, that in structural engineering, an unchecked assumption was the thing that brought a bridge down. That you could not afford to sign off on something you hadn't fully understood, that the same rule applied to any document you put your name on in any part of your life. Blythe said she thought she wanted to study law. Norman didn't hesitate. He said he thought that was a good idea. When the tuition invoices arrived for Osgood Hall Law School, Norman sold the proceeds from a secondary contract. One he had meant to reinvest in a second inspection vehicle to cover the first year. The company was tight that season. Rowan, who was 19 by then and had started working at the firm part-time, stood in the kitchen doorway and told his father plainly that Blythe was their family and the company would find another vehicle, that they would carry this together. The company did find another vehicle. In fact, within 5 years, it had 22 of them, and federal contracts running from Halifax to Prince George, and a private infrastructure database that the Department of Transport had twice attempted to license before Norman decided it was worth more to keep it in-house. Wyatt Structural Group grew from a garage operation into a firm with 400 employees and a portfolio of contracts that made it, by most honest assessments, the most reliable name in civil infrastructure inspection east of Calgary. Norman himself became what the industry called a company man in the truest sense. He showed up at job sites in steel-toed boots. He still read every significant contract himself before authorizing a signature and he took his lunch with the field teams instead of the clients. To the board of directors he had been persuaded to assemble as the company scaled, this was becoming a problem. Clifford Sears had joined the Wyatt Structural Board 3 years earlier, recommended by an investment firm. Norman had brought in to help manage the company's pension obligations. He was 60, polished in the specific way of men who have never built anything themselves, but have sat on enough boards to have developed strong opinions about those who do. He wore the right suits and said the right things in meetings, and for 2 years Norman had found him tolerable, if unnecessary. What Norman did not know was that in those 2 years, Clifford Sears had been cultivating a quiet alliance with Yvonne Dalt, the chief executive of Dalt Capital Partners, a Montreal-based private equity firm that had been circling the infrastructure sector for 18 months. What Dalt Capital wanted was Wyatt Structural's federal contract portfolio and its inspection database. What Yvonne Dalt understood was that the fastest path to acquiring both was to remove the founder first. The scheme they devised was unhurried and methodical. Sears manufactured a legal claim around a founder's trust that Norman had established years earlier. A trust that held a portion of his founding shares and listed Blythe Henshaw Wyatt as its named guardian. The trust was real. Everything else about Sears's interpretation of it was fabricated. Sears claimed, in court documents filed with the Ontario Superior Court, that Norman had been systematically transferring company assets into a private fund held in the name of his adopted daughter, a girl, the filing noted with clinical precision, who shared none of his biology and whom he had retrieved from a transit platform. The goal was to convince a judge to freeze Norman's voting rights, to separate him from the founder's chair, and to sell the crippled company into the hands of Dalt Capital at a price that would represent, for Sears, a very comfortable consulting arrangement. The documents Sears produced bore Norman's signature. The transfers bore dates that were real. The trust account bearing Blythe's name was real. Everything else was framing. The story reached the press within 48 hours. The same industry contacts who had praised Norman's rise for a decade began calling him sentimental, calling him reckless, suggesting that a man who let personal loyalty override fiduciary judgment had no business running a firm of that scale. Rowan wanted to respond immediately, to go directly to the press with the full timeline, to tear the accusation apart in public. Norman put his hand on his son's shoulder and told him to hold still. He had spent 20 years in structural engineering, and he knew that the worst thing you could do to a compromised load-bearing structure was to disturb it before you understood where the actual failure point was. What cut Norman in those days was not the money. He had been broke before, and he was practical enough to know he could manage it again. What cut him was the way they had taken Blythe's past and turned it into a ledger entry, the way they spoke of the girl on the platform as a liability that a serious man would never have incurred. The filing used the phrase misplaced parental sentiment twice in its opening paragraphs. On the final evening before the hearing, a courier delivered a formal summons, 72 hours. After that, a judge would decide whether to freeze his controlling shares. By then, everyone who loved Norman had already called Blythe. She was a barrister and solicitor in Toronto, specializing in corporate trust law and securities fraud, which was, as Rowan noted quietly to Beverly Stowe one afternoon, precisely the combination of expertise that the situation required. Beverly, who had been Norman's office manager and paralegal for 14 years, and who kept every file that mattered in a locked cabinet she called the vault, agreed. But Blythe wasn't answering. Her firm said she was out of office. Her apartment in the annex went dark. Her mobile went to voicemail after the first ring. The silence stretched out for 48 hours, and then Clifford Sears found a way to use it. He called a contact at a national business publication and said, with rehearsed sorrow, that even Norman Wyatt's own adopted daughter would not appear in his defense. And surely that told you something about the state of things. Yvonne Dole gave a television interview from the lobby of her Montreal offices. She was composed and measured, and she said that sentiment was not a business strategy, and that the Wyatt structural story was ultimately a cautionary tale about what happened when a company outgrew its founder's judgment. Norman sat in his office in Hamilton the morning before the hearing, and he picked up a photograph from his desk. It had been taken at that Tim Hortons on the night they met, Blythe in her thin hoodie, holding her hot chocolate with both hands, not yet trusting enough to fully sit back in the chair. Rowan had found it in an old phone backup years later and had it printed. Norman had kept it without making a fuss about it. He held it for a while. Then he told Beverly Stowe, who was sitting across from him with a yellow legal pad, that Blythe owed him nothing at all. He had not gone back to check on her so that she would one day return the favor. He had gone back because a child was sitting on a platform in a February sleet storm, and he had it in his power to do something about that, and that was the beginning and end of the arithmetic. Beverly wrote nothing on the legal pad. She just nodded. What no one in Hamilton knew was that Blythe was in Edmonton, in the back room of an archival law office, working her way through a cabinet of files that Beverly Stowe had mentioned to her 2 years earlier. Materials from the company's founding period that Beverly had insisted on keeping in hard copy because she had always distrusted the assumption that digital records were permanent. Blythe had been looking for the original of the Wyatt Founders Protection Trust. Not the version Sears had attached to his claim, but the original instrument with its full annexes and its statement of intent, a separate document that Sears had very carefully not included in anything he filed. She found it at 11:40 at night, in a sealed manila folder at the bottom of the third cabinet. On the outside, in Norman's handwriting, the careful, level printing of a man trained to produce field notes that could be read in any lighting condition, were words she read 3 times before she allowed herself to sit down on the floor. The folder was labeled, Blythe Henshaw, called Wyatt, to be opened in the event the company requires defending. She sat on the cold floor of that archive room for a long time. The girl who had held a hot chocolate with both hands, and the lawyer who had come to Edmonton alone in the middle of the night became for a moment the same person. Then she opened the folder and got to work. The arbitration hearing convened in a downtown Toronto office tower on a gray October morning before arbitrator Pauline Arnott, a retired Ontario court judge with a reputation for impatience toward theatrics and a precise memory for documents. Norman sat at the defense table beside a solicitor who had been retained 4 days earlier and who was competent but operating at the edge of his preparation. Across the aisle, Clifford Sears sat with Preston Vale, a litigator, whose firm billed itself as specialists in hostile corporate restructuring, and who had spent the past decade winning cases where one side had considerably more resources than the other. Preston Vale opened with the confidence of a man who had won before he started. He put the wire transfer records on the screen. He put the trust agreement on the screen. He put Norman's signature, enlarged, beside the agreement. And then, with the deliberate pause of a man who understood that timing was its own form of argument, he put the adoption papers on the screen. He told arbitrator Arnott that the story was simple. A founder, operating under what he called unchecked familial bias, had moved company assets into a private instrument held in the name of a woman he had, by his own account, taken home from a transit platform 16 years earlier. The trust was not a corporate instrument. It was a private arrangement dressed in corporate language, and the board of directors had a fiduciary obligation to the other shareholders to address it. He asked Norman directly whether he had adopted Blythe Henshaw. Norman said that he had. Preston Vale asked whether he had established a trust bearing her name. Norman said that he had. A sound moved through the room. Norman's solicitor rose to explain that the trust was entirely lawful, that it had been filed and renewed according to its terms, but he did not have the original instrument in front of him, and the words landed without the weight they needed. Arbitrator Arnott looked at both sides. She asked whether the defense had additional documents or witnesses to present. Norman's solicitor said he was still pursuing certain records. Pauline Arnott looked at the clock. She picked up her pen. The doors at the back of the room opened. A woman in a dark blazer and white shirt walked in carrying a leather briefcase and a manila folder held against her arm. She did not move quickly. She didn't apologize for the timing. She walked to the clerk's station and said, in a clear and even voice, "Blythe Henshaw Wyatt, barrister and solicitor. I'm entering an appearance as counsel of record for the respondent and moving to introduce emergency documentary evidence." The room went quiet. Norman turned in his chair. He did not see a barrister. He saw a teenager on a February platform, holding a cup of hot chocolate with both hands, asking if someone was going to forget about her. He held that image for exactly 1 second. Then he watched her turn to face Arbitrator Arnott and wait, without fidgeting, for the room to come to her. Preston Vale objected on conflict of interest. The woman appearing as counsel was the very person named in the allegedly improper trust. Blythe answered him with a precision that carried no heat. She said that since the opposing party had chosen to place her identity and her history at the center of their claim, she had standing to address both the documentary record and her own role in it. She was not appearing as the beneficiary of the trust. She was appearing as the person who understood its terms better than anyone alive. Arbitrator Arnott gave her 5 minutes for a preliminary statement. Blythe drew the original Wyatt Founders Protection Trust from the manila folder and placed it before the arbitrator. She walked Pauline Arnott through the document's plain language. The trust did not move company assets into Blythe's personal possession. It did the reverse. It placed a portion of Norman's founding shares into a protected instrument for the express purpose of preventing the board from selling the company in violation of the principles under which it had been built. Blythe was not the recipient of the funds. She was the named guardian of the founding shares, appointed to protect them in precisely the event that was now unfolding. The silence in the room changed quality. Blythe then read from a letter that Norman had appended to the trust on the day her adoption was finalized. It had been formally incorporated into the instrument by reference, and it spoke with the full legal weight of the document that contained it. She read it quietly and without performance. Norman had written that he had already lost one family and intended to conduct the rest of his life in a way that did not require him to lose another. He had written that he was not establishing the trust to enrich his daughter, but to protect the company from people who would treat it as a commodity to be stripped. He had written, "If the board ever uses Blythe's history as an instrument against the Wyatt family, that action itself constitutes proof of betrayal, and the protective provisions of this trust shall take immediate effect." Preston Vale was already on his feet, already reaching for the argument that whatever the letter said, the clause had surely lapsed with time. Blythe set a second folder on the clerk's table. It contained the annual renewal filings for the trust, 16 of them, one for each year since the instrument was created, each submitted on schedule. She submitted a signed affidavit from Beverly Stowe confirming that every filing had been made transparently, included in the company's regulatory disclosures, and delivered to the board secretary's office without exception. Beverly Stowe was called to the stand. She took her oath with the steadiness of someone who had been waiting a long time to say what she knew. She confirmed the filings. She confirmed the disclosures. And then she confirmed the thing that made Yvonne Dolt, sitting in the rear of the chamber, stop looking at her phone. Clifford Sears had instructed his counterpart in the board secretary's office to reclassify the trust renewal filings as routine legal maintenance and to exclude them from the quarterly reports distributed to directors. He had buried the very documents that would have shown the rest of the board that Norman had done everything. In the open, Blythe moved to her second file. She produced a chain of messages exchanged over 18 months between Clifford Sears and Yvonne Dolt. In them, Sears referred to Norman as the site foreman with the foster kid problem. He and Dolt discussed using the trust as the legal trigger for the claim. They discussed the timing of the press leak. They discussed what they called the sentimental angle, and how to use it against a man whose entire reputation was built on being trusted. A forensic analyst had verified every message. Blythe entered the certification into the record before Preston Vale could object to the provenance. Then she entered a payment record, a transfer from a shell company registered to a numbered corporation linked to Dolt Capital Partners, deposited into a consulting account belonging to Clifford Sears. The amount was substantial. The date was the same day Sears had filed the initial claim. Arbitrator Arnott turned to Clifford Sears and asked him, in a voice from which all neutrality had drained, to explain the payment. Clifford Sears looked at his solicitor. His solicitor looked at the table. Blythe let the silence settle. Then she told Arbitrator Arnott that there was one further piece of evidence. Before the hearing, she said, she had been contacted through an intermediary representing Dolt Capital Partners. The intermediary had offered her a senior partnership position at a Bay Street firm and a signing package, contingent on a single condition, that she not appear in the arbitration, that she simply stay home, that her silence was all that was required. She had recorded the meeting. She had recorded it lawfully and in full, in accordance with the relevant provisions of Ontario law, because her father had spent 16 years teaching her that the first obligation of any careful person was to protect the truth before trying to use it. She played the recording through the room's speaker system. The intermediary's voice was clear and unhurried. It said, "Dolt Capital doesn't need you to testify against your father. They only need you not to show up." The room was very still. Norman looked at his daughter. He understood, for the first time, what those 2 silent days had actually cost her. The weight she had carried alone, the people she had walked directly toward, the evidence she had gathered while letting him believe for 48 hours that she might not be coming. She had not abandoned him. She had gone quiet deliberately, moving through the back of the structure, while her enemies held the front entrance, because she had known they would have closed ranks the moment they saw her approaching. Arbitrator Arnott ordered the recording entered into the record. She noted with a formality that contained something colder beneath it, that the evidence raised serious questions about the manipulation of a witness and the integrity of the proceeding itself. Then Blythe moved to the provision of the Wyatt Founders Protection Trust that Norman had drafted 16 years earlier and had never, until now, expected to use. She read it into the record at measured pace, so that every person in the chamber could follow it. The clause stated that if the founder were attacked through a financial accusation tied to his family, and if that accusation were demonstrated to have been manufactured in service of a hostile acquisition, then the founding voting authority held in the trust would pass temporarily to the trust's named guardian, pending the conclusion of the investigation. The named guardian was Blythe Henshaw Wyatt, effective upon her admission to the bar. The clause had been renewed annually for 16 years. Clifford Sears had known about the trust. He had read it well enough to know which parts to bury. What he had apparently not done, perhaps because he could not imagine that a teenager found on a GO Transit platform would one day be worth taking seriously, was read it all the way to the end. Preston Vale objected to the admissibility of the original instrument. He objected to the certification of the messages. He objected to the recording. He objected to the standing of the clause. His arguments grew louder, and then somehow thinner, the way arguments do when they are fighting a position that has already collapsed. and the speaker is the last one in the room to accept it. Arbitrator Arnott reviewed the documents for 7 minutes in silence. Then she issued her order. Norman Wyatt's authority over Wyatt Structural Group was not to be frozen. All transactions involving Dolt Capital Partners were suspended immediately. Pending a full investigation, Clifford Sears was removed from all board functions until the matter was resolved. Blythe Henshaw Wyatt was formally recognized as the temporary holder of the founding voting authority, the mechanism the conspirators had built to destroy. Norman had, in its final motion, transferred power to the person they had dismissed as his only weakness. The corridor outside the hearing room was marble and fluorescent, and largely empty when Norman and Blythe found each other there. They were both tired, in the specific way of people who have been holding something together through an act of will and have only just been permitted to set it down. Norman looked at her for a long moment. Then he said the thing that had been sitting in his chest for 2 days. He said, "I thought you had gone." Blythe said, "I learned from you. When someone builds a trap in front of the door, you find your way in from the back." Norman told her he was sorry, that they had dragged her history into that room and weighed it against her in front of strangers. She shook her head. She said that people like Sears and Dolt always assumed a person's difficult beginning was something they would spend their lives apologizing for. She had never felt that way about it. Where she had come from had taught her what it meant to actually need something, a roof, a door that opened, someone who called the next morning. It had given her a precision that her opponents, who had never needed to read the fine print for their own survival, simply did not have. Norman asked why she hadn't told him the plan, why she had let him sit in that office for 2 days believing she might not be coming. She said, "Because if I had told you, you would have spent every hour trying to make sure I was safe, and I needed them to believe I was unreachable. The moment they knew I was moving, they would have moved first." She paused. Then she said, "This time I needed to be the one doing the protecting." Rowan found them at the end of the corridor and pulled his sister into a rough hug that said everything he couldn't organize into words quickly enough. The three of them stood together in the plain fluorescent light for a moment that required nothing added to it. In the weeks that followed, Clifford Sears cooperated with investigators in the hope of moderating the charges against him. The cooperation didn't help as much as he had hoped. Yvonne Dolt lost the acquisition and found herself the subject of a securities investigation that would follow her for years, and that would eventually produce results she had not anticipated when she made the call to approach Blythe through an intermediary. Norman restructured the board from the ground up. He asked Rowan to take formal responsibility for the company's field operations, the domain his son had been running informally for 3 years, and that he was by any measure the right person for. He asked Beverly Stowe to oversee the company's compliance and document practices, because she had been the one keeping the actual record straight, while everyone else was managing appearances. And he invited Blythe to serve as permanent legal counsel to the Founders Trust, not as a family gesture, but because she had demonstrated, in a room full of people who had bet against her, that she understood the document and its intent better than anyone alive. Blythe accepted on the condition that she would answer to the instrument and to the facts and to nothing else. Norman said that was exactly what he was counting on. He called a meeting for the full company at the inspection yard in Hamilton. 400 people in hard hats and high-visibility vests, standing in the November cold with their breath showing. He told them a short story about a GO Transit platform and a February sleet storm and a girl with a bruise on her jaw who had asked whether anyone would remember she existed after tonight. He did not tell the story to present himself as a good man. He told it to remind everyone standing in that yard what the company had been built on. The understanding that the work only stayed honest if the people doing it were treated as though they mattered. Blythe stood beside him while he spoke. Not the girl from the platform, not the foster kid from someone's file. The woman who had walked into an arbitration chamber without hurrying and without apologizing and had laid 16 years of meticulous preparation on the clerk's table and waited for the room to catch up. On an ordinary morning a few weeks later, Norman was standing at the edge of the inspection yard, watching his field teams load equipment for the day's jobs. Blythe came to stand beside him. She reached into the pocket of her coat and pressed something into his palm. It was the maple leaf keychain, the spare key to the front door of the house in Dundas, worn smooth from 16 years of being carried. She said, "You gave me a key when I had no door. I'm giving you back the key to everything you almost lost." Norman turned it over in his fingers. He thought about the platform. He thought about the hot chocolate and the too-thin hoodie and the question that had lodged in him and never entirely let go. Then he slipped the keychain into the breast pocket of his work vest, the same vest he wore every time he went into the field, and watched the convoy pull out of the yard in the clear November light. The company was still his. The promise he had made on a February platform in a sleet storm, "The door is always unlocked for you," remained as whole and unbroken as the night he first spoke it.